Hi everyone, Lee Pacchia here, and you're watching the Markman Minute, where we bring you the hottest stories at the intersection of IP law and investing. I'm joined by Gaston, as always, who joins us from a hotel room in Tyler, Texas. You just got in, I'm told. Hope you had a safe trip down there. Let's start off with the obvious, Gaston. Why are you in Tyler, Texas?
In addition to being the rose capital of the world, Tyler, Texas is famous for being the patent litigation capital of the world. And there's a good chance on any given week that if there is a patent trial of interest to investors, it's happening down here in Tyler or in Marshall or one of the other jurisdictions in the Eastern District of Texas. So anyone who's practiced patent litigation for the last 10 years knows this area well, has done the drive down from Dallas or Houston, with Cal's as company, and, knows the area well and knows the courthouse well. And it's something that just is par for the course until the rules change and plaintiffs are not able to file cases down here anymore, if that ever happens.
Like Delaware is to bankruptcy attorneys. We'll get to the jurisdiction a little bit more in a moment, but first, tell me about this case you're working on. What is it, and what do people need to know?
All right, well, we're actually here on behalf of some investor clients doing what we consider to be a big part of what we do at Markman Advisors, which is helping to handicap trials and other litigation events and try to help our clients get a pulse of where a particular case is going. And the case I'm down here for now is actually been being tried for the past week. The idea is that it's going to head to closing arguments and perhaps a verdict either today, tomorrow, Wednesday, but sometime this week is the expectation. And it's actually a pretty familiar name for a lot of investors. It's a company called VirnetX's. The stock ticker is VHC. And VirnetX has been engaged in many years of litigation with a host of large technology companies, chief among them Apple. And VirnetX has definitely had its ups and downs, both in terms of share price and in terms of results in terms of asserting their patents. But we're really here for what I like to think of as VirnetX's last stand, which is a patent trial involving multiple patents and multiple patent families, once again with Apple in the crosshairs. So it's a pretty big event from a patent infringement perspective, and it's also something that's of some interest for investors as well.
Yeah, now I know you can't get too granular here for obvious reasons, but can you talk to us a little bit more about some of the issues at play here?
Yeah, VirnetX is, like I said, there's a long litigation history with VirnetX and its patents, and it's actually a great case study for investors who want to see the changing fortunes of a patent assertion entity over the past 5 or 6 years as we've gone into the age of the IPR, the age of Alice, the age of a federal circuit that's been a little bit more aggressive in terms of damages issues and some other issues. But it would probably take an hour to summarize all the different patent things that are going on with VirnetX. But in a rough thumbnail, this trial is ongoing. It concerns Apple's FaceTime product, which is something that people are very familiar with. It also concerns some patents that VirnetX has that Apple has previously been found to infringe related to secure VPN technology. And it's really about VirnetX arguing that Apple's products are more secure in part because of VirnetX's technology. And that's why we're here. In a previous iteration, VirnetX was able to get a $368 million verdict against Apple. That verdict didn't hold up on appeal, but they're getting the proverbial second bite at the apple, and literally.
And this is their last stand, you said?
I believe so. They've already, in the past couple of years, VirnetX has lost a high-profile trial on the same patents to Cisco. Cisco defeated them wholesale. At the same time, VirnetX had some success in getting Microsoft to pony up a couple of $100 million for the technology. But when you think about the ecosystem that we're in, and you think about the fact that VirnetX's patents are being reviewed in the patent office under IPR, this may be the last chance that they have to generate a real headline that excites investors. And I don't think anything would excite VirnetX investors more than the announcement of pretty big verdict against Apple.
Sure. So you said before that Tyler, Texas is a hot jurisdiction for people in your line of work. That's news to me. Why is it?
Well, there's a couple of reasons, and this is not a recent phenomenon. The golden age of the patent troll, as people will be talking about in the coming years, really coincided with the use of the Eastern District of Texas as the jurisdiction of choice. A couple of reasons have been forwarded for why patent cases and patent plaintiffs have done well down here. Everything from the fact that the concept of a royalty is familiar to people in East Texas because of the oil and gas industry and the fact that a lot of them get royalty checks for oil drilling on their property, to the fact that this was prior to the patent world. This was known as one of the tort hotbeds, with juries that had a predilection for giving out big verdicts. But probably the number one reason that patent cases have flourished down here is because the judges, the federal court judges in the Eastern District of Texas have welcomed patent cases. They were one of the first jurisdiction to set up patent rules to help get the cases moving smoothly. They're considered very friendly to plaintiffs with respect to issues like transfer and case management. So I think for all the variety of factors, Eastern District has and will probably remain one of the jurisdictions of choice for patent plaintiffs.
Gaston, always a pleasure. Thanks for your time today, sir.
All right, thank you, Lee, and hopefully we'll have more to deconstruct after the verdict comes in.
Right on. That's Gaston Krug from Markman Advisors. If you'd like to see more of the stuff we're working on, be sure to go check us out online. You can find us at mimesislaw.com under the IP Flow tab. I'm Lee Pacchia. Thanks for watching.
Well, actually, there's some pretty big news out of the Supreme Court, actually. Obviously, whenever the Supreme Court takes an interest in patent issues, people tend to get excited. Everything from the Alice decision that we've talked about in the past, which impacted on the value of software / business method patents, to some of the earlier decisions